Good morning, everybody. So it's indeed my pleasure to be able to give a short talk here this morning on big data, and specifically the area that we are working most on as a law firm is data protection issues surrounding big data. And actually, this isn't a very new topic. We actually had a very relevant big data case already coming up in Belgium in the 90s. And I always like to use this case to illustrate the difficulties and the challenges around big data because it's something that's very intuitively understandable. In this particular case, a bank was analyzing the transactions made by its customers, basically just looking at the movements on bank accounts, specifically to identify which of their customers were making home insurance payments to a competitor. For this bank, this was particularly relevant because they offered competing insurance packages. They could find out who was a customer in the market of these kinds of insurances. And most importantly, and this is also what they did, they could see how much these people were paying for their insurance. So they could send all of those customers a very competitive bid that was slightly lower than what their competitors were offering. Basically, they were using the bank account information, bank transaction information, as the perfect market analysis tool, giving them perfect insight into where the business opportunities were and how they could benefit from that. They were, as you might imagine, ultimately taken to court for that and convicted for unfair market practices, with the judgment noting that this was also a violation of data protection rules since they were using bank account data for different purposes than agreed with the customer. I always find this a very interesting case because it shows two things very clearly. First of all, there's the element that I think is intuitively clear to most people, that there are some big privacy issues here. I don't think anybody in this room feels comfortable with the idea that their bank is going through their transactions, looking at where you're spending money, and looking at particularly how they can market their own services better to you. So there is that privacy issue that is, I think, worrying to anybody who hears about this. But there is also the second issue, which I think a lot of people might also note. This actually was an approach that allowed the bank to provide cheaper insurance offers to their customers. There was a benefit to their customers. There was a trade-off here. Customers suffered a breach of their privacy, which was ultimately, and in my opinion, rightfully considered to be unlawful. But the approach did result in customers getting better offers, better deals for their insurance needs. So there was also a benefit here. And this shows the tension that you always have between big data, the need to make sure that people understand what's happening, that you're informing them correctly, and looking also what the major implications are. Here it's also a lot easier because the customers always got a benefit. Nobody actually had to pay more as a result of the big data analysis. If that bank information had been used to identify cases where premiums might go up as a result of your behavior, then I think the uproar would have been much bigger. The interesting part is that this is a case that was tried already on the basis of existing data protection rules. So the Data Protection Directive, as it's already in vogue, which has rules on the purposes that allow you to process personal data. It also has rules, actually, even the current directive, on profiling, basically by specifying that you as a citizen may not be made subject to decisions that have been made purely through automated processing. This was actually not so much a rule that was introduced as a response to fear of big data, but more of a Kafkaesque future vision where people were wondering, well, we are going to be a part of a society where computers are taking decisions that materially affect you and I as citizens, and we won't have anybody even to go to. We won't have any means of redress. We won't be able to ask, hey, what happened here? How did you arrive at this decision? And this was an element that the current legal framework already aims to address. As probably all of you know, the European privacy rules have been under revision for quite some time now. The new data protection regulation is on the way, and that also includes a sharpening, a tightening up of the rules on profiling. The rules for that have been expanded quite significantly with the purpose of shaping much more clearly what is permissible and what is not permissible. Basically, if you look at the proposals that have been made in 2012, they very clearly specify that citizens have the right not to be subject to profiling and not to be subjected to automated decisions that have been made on the basis, solely on the basis of their personal situation, their personal aspects, things like their economic situation, their health, their personal behavior, and so forth. There are exceptions to that because, as you might guess, all of us are very frequently subject to that kind of automated decision making, and in many cases this is a good thing. To give you a very simple and intuitive example, when you file your taxes, you provide the government with the exact data on how much money you make, what your expenses are, and so forth. And actually it's a computer that makes a decision on how much money you owe. That's fine because that means we have a clear objective mechanism, a clear and objective system. We do, however, need to make sure that if you don't agree with your tax assessment, you have somewhere to go to. And this is a requirement that you have also under European data protection rules. And this is something that is increasingly being emphasized. Automated decision making is fine, even if it affects you and affects your legal position, but you still need to have the opportunity of seeking redress with an actual physical person. You need to have somebody to talk to. Another rule that's very important, that's being emphasized much more and more in current revision of data protection rules, is the concern about discrimination on certain grounds that, at least on the basis of European principles, European human rights, you consider to be unacceptable. Probably many of you have heard the example that came up, actually not even in the context of data protection, where the Court of Justice ruled that it's unlawful for insurance companies, car insurance companies, to distinguish between their customers on the basis of gender. If the only difference between customer A and B is the fact that one is a man and one is a woman, that's not a lawful basis anymore for car insurance companies to offer you a different service fee. This is an interesting example because this is a case where car insurance companies could say, well, actually, there is an objective difference. Women are objectively, from our perspective, safer drivers than men. We can argue about whether this is because women are objectively better drivers or because they have different driving patterns, but the fact is, women cause less accidents than men. So for an insurance company, that kind of profiling, because even this type of thing is profiling, is a very good and very useful way of making an objective assessment of what your risk is and what the resulting costs are. Nonetheless, there are special categories of data that are considered to be highly sensitive under data protection rules and which are not allowed to be used as a basis for profiling decisions, for basically making decisions that will affect your legal situations or that significantly affect your interest. And this includes things like gender, also gender identity more broadly, but also things like your political views, membership of trade associations, of your health situation, and so forth. So there are actually quite a few criteria that you're no longer allowed to use. That doesn't mean that that law is entirely settled. We do have some negotiations which are ongoing. The proposal for 2012 has been revised in the last couple of years. And to a large extent that has been done because we want to make sure that that legal framework isn't so strict that it doesn't match anymore with the market realities. So to give a couple of simple examples, the original 2012 proposal of the regulation basically said that citizens had the right not to be subjected to profiling and to automated decisions. The text that we currently have, 2013 version, is much more nuanced. It gives citizens the right to object to profiling, which is slightly different from saying that you have the right not to be subjected to profiling. One is basically focusing more on the fact that profiling is objectively something that's bad for you from a perspective of privacy. The other one gives you more of an opportunity to assess that yourself as a citizen, as a person, on whether you consider profiling to be beneficial to you. There's also in the current proposal much stronger focus on transparency, so on the fact that you as a citizen need to be informed when you are being profiled and how that affects you, and you need to have the opportunity to revoke your consent. If you've given your consent to profiling, you need to be able to revoke that consent so that you can basically opt out of those measures. So I think this also matches with previous speakers' call for some regulatory humility, because this is one of the major issues that we have with big data. We see a lot of business opportunities. We see a lot of privacy challenges and privacy risks as well, a lot of concerns that need to be managed. But what we have to be very careful about is we don't want to introduce a legal framework that makes useful services, useful big data services, which there certainly are, impossible. And this is why I think it's very beneficial that at least the current versions of the proposal, the current versions of the regulation, don't just focus anymore on what's not allowed and what is forbidden, but also focus much more on implementing measures that ensure the lawfulness of big data profiling. So these include things like informing you as a citizen what's happening, giving you the opportunity of giving your consent or withdrawing your consent to profiling, and making sure that when profiling occurs, the person doing that has to take appropriate measures to make sure that they're not unlawfully discriminating against you and that your interests are safeguarded. Basically making sure that in the future, even within big data use cases, you still have the opportunity of finding out who is actually making decisions about you and how you can address that person. I think that's the best way of making sure that we can get the benefits for big data while making sure that there's still a human face behind it, which I think is one of the principles that everyone in this room is also concerned about. We don't want to get into a situation where decision-making becomes fully automated and where we no longer have any kind of right of redress as human beings.